Hi, I'm Alex Reinert. I'm a law professor at the Benjamin and Cardozo School of Law.
Excellent. And we're discussing today your article, Reconceptualizing the Eighth Amendment, Slaves, Prisoners, and Cruel and Unusual Punishment. So could you kind of outline what you did in your article?
Sure. It's my pleasure, and it's great to be here. So this paper came about because the first article that I wrote was an article about the Eighth Amendment jurisprudence, and it's an area of law that I've studied and also worked in as an advocate. Most of my 20 years of experience as a lawyer has been working with incarcerated people. And so as I was doing my research for that paper, I kept running across these 18th and 19th century cases involving enslaved people in which the language of cruel and unusual punishment was used. And cruel and unusual punishment is the language from the Eighth Amendment. And I sort of put it in my head, set it aside because it wasn't relevant to the paper that I was working on, but thought I'd like to come back to that someday. And so this is a paper that reflects me coming back to it. And it took some time for me to work through it for a variety of reasons. But the premise of the paper is that in discussions about the Eighth Amendment, there's a lot of talk about what these words mean, cruel and unusual punishment. And it's hard to get a sense of it if you only look at debates surrounding the Eighth Amendment. And so for people who are originalists, who care about the original meaning of the term, there isn't a lot of information that we can glean from the public record involving the debate in the Eighth Amendment. So my goal was to look at the law of slavery and see if we could learn anything useful about the meaning of these terms, at least as they were understood in the 18th and 19th century, around the time that the Eighth Amendment was adopted, and then leading up to the Reconstruction era, when the 14th Amendment was adopted and when the Eighth Amendment eventually became applicable to the states. So that's the goal of the paper. And I guess I could say, I think broadly, and I know we're going to talk in detail, but I think broadly, I learned, or at least I think there are two useful insights to glean. One is that to the extent that there's a debate about whether or not the Eighth Amendment includes a principle of proportionality, and I know we'll get into discussing what exactly that means. To the extent there's a debate about that, the law of slavery suggests that the words cruel and unusual punishment were interpreted to mean, to include some proportionality principle. So that's one thing. And that to me is relevant to originalists or people who care about original meaning. There's another piece to it, which is the law of slavery is also impoverished in the sense that I want to be really, really cautious at the outset and say that when I talk about the law of slavery, it's the formal law of slavery. It's not the actual experience of enslaved peoples. That is, some of the law of slavery is just a myth. That is, it was what courts were saying they were using to protect enslaved people. But in reality, enslaved people were subject to routine abuses, horrific abuses that should have been condemned by the law of slavery as it existed, but it often was not. So I want to be really clear about that. But even if one just looks formally at the law of slavery and compares it to the current law of the Eighth Amendment, I think for someone who's not an originalist, but who's a dynamic interpretivist, that is, who thinks that the law should evolve, I think that person would be shocked by how little we have traveled from the 19th century and conceptions of cruel and unusual punishment to today's conception. So that's the broad brush, and then I think I should stop and we can talk about some things in more detail.
Yeah, and I'd like to, I mean, that was an important point that I got from the article as well, that the law of slavery is different than kind of the everyday life of the slave, and that the very system of slavery itself was cruel and unusual to begin with.
Yeah.
So you can't, then the law of slavery is the court cases. Maybe you could talk more about kind of what the law of slavery is.
Sure. So where do we find this? So I'll start before the enactment of the Eighth Amendment in the colonies in the 17th and 18th centuries, there were really two sources of supposed regulation of the treatment of enslaved people. There were some statutes in some slaveholding states. Virginia most prominently had developed some statutory law regarding the treatment of enslaved people. And then there was some common law as well. And so just for the lay audience who doesn't know the difference between those things, statutes we probably all know are passed by legislatures or people who are elected in some way, shape, or form. We call that positive law in some way. Constitution is positive law as well. And then common law is law as it is developed by the judges. It's unwritten in the sense it's not codified, but you can find it in the cases. So if you look to both of those sources, pre-8th Amendment and post-8th Amendment, there's a convergence around the idea of cruel and unusual punishment as being the standard for the treatment of enslaved people. And so where do we see these kinds of standards emerge? Mostly we see them emerge in cases involving slave owners who are suing for damage to an enslaved person who was harmed by somebody else. So this is another critical difference between the rights of incarcerated people and the rights of enslaved people. Even though I'm talking about the law of slavery and talking about the way in which this law, at least formally, pretended to protect enslaved people themselves could not bring, in most jurisdictions, could not bring an action. It was always an action brought by a slave owner protecting what was thought of as their property at the time. But nonetheless, the principles that emerged from those cases coalesced around the idea that enslaved people shouldn't be subjected to cruel and unusual punishment. So that's mostly where the law of slavery comes from, some statutes and then a lot of common law. So it means digging through all these cases from the 18th and 19th century in which civil actions are brought, some criminal actions, although criminal actions were rare. Sometimes there were criminal actions brought against an actual slave owner, a slaveholder, but that was rare. Usually it was a criminal action against maybe an overseer or a stranger who had inflicted punishment or inflicted harsh treatment on an enslaved person. So that's where the law of slavery comes from.
And most of the cases that are mentioned in the article usually resulted in the death of the slave. Is that correct? Because they didn't have the agency to bring their own cases. It always was after the fact. Is that?
Well, so I think I think we could divide it into two categories. In most of the jurisdictions, a slave owner was only liable if they were liable at all criminally when an enslaved person was killed or maimed by the treatment of the slave owner. So if there's going to be a criminal case against a slave owner, it's always going to involve death or maybe sometimes maiming. Things were slightly different for so-called strangers or for people who did not formally have own slaves as property. And for those people, sometimes there were cases brought in which it was about harsh treatment where the slave actually had survived. And one case I remember discussing in the article was sort of a convergence of both prisons and enslaved persons. It was someone who had tried to escape, and the slave owner asked that the sheriff take them into custody. And then the sheriff didn't provide them with adequate food and shelter, and the enslaved person was harmed. And so then the slave owner sued. And the court said, this person, this deputy, has responsibility to care for the enslaved person. The fact that they're an enslaved person doesn't mean that that the deputy owes no duty to them. There's still a duty to them. So there was a convergence of both the law of prisons and the law of slavery.
Yes, I want to get back to that because various things. But if we could talk a little bit more now about the proportionality in this context.
Sure. So let me frame it. Let me set up the discussion, which is in the Eighth Amendment context. Since the 1970s, there's been a live debate amongst justices on the Supreme Court about whether the Eighth Amendment contains a so-called proportionality principle. Now, what does that mean? For people who care about it, what it means is, does the Eighth Amendment only regulate the way in which someone is punished, that is the mode of punishment. Maybe the mode of punishment is electrocution. Maybe the mode of punishment is whipping. Maybe the mode of punishment is solitary confinement. So one argument is that's all that affects is what kinds of punishment you can inflict on someone. Or does it also regulate the excessiveness of the punishment? So why does this matter? Well, it matters in, let's say, cases involving life without parole, or cases involving long terms of imprisonment, in which everyone would agree that imprisonment is an acceptable mode of punishment, at least under the Eighth Amendment. But could one argue that imprisonment for too long is disproportionate and therefore a violation of the Eighth Amendment? That's where the proportionality principle kicks in. So in general, the people who argue that the Eighth Amendment doesn't contain a proportionality principle, we'd associate with originalist constitutional jurisprudence. That is, they look only at the text or at the original meaning, and they think there's no proportionality principle. And the people who think there is a proportionality principle, I think we'd associate with so-called living constitutionalists, dynamic interpretivists. So that's the conflict. And the way it gets framed, let me just frame it for the law of slavery, is one thing I was looking at as I was reading through these cases was, well, when these common law jurisdictions, when these judges interpret these statutes, or when they interpret the common law, and the language they're interpreting as cruel and unusual punishment, did they find that that contained a proportionality principle? And almost always they did. So indeed, sometimes they would say, a punishment can be cruel and unusual in the context of slavery, even if it doesn't involve a so-called unusual mode of punishment for the context of slavery. So, so that to me was a significant insight, because if I were an originalist, or if I was someone who cared about original public meaning, then to me this is instructive as to whether or not the same language used in the Eighth Amendment also should be interpreted to contain a proportionality principle.
That's very clear. Thank you. So can we talk more about the actual language of cruel? What do cruel and unusual mean? Because as you said, there was very little debate about this amendment opposed to others. And maybe you could speak to a little bit about why and how.
Well, so let me say a little bit about why it seems like there was so little debate about it in the context of the Eighth Amendment, which is, I think, number one, it's possible the framers were focused on other things that were more controversial to them. The First Amendment, the Fourth Amendment occupied a lot of time during the convention. The other thing is the language cruel and unusual punishment did come from other sources of authority. So it was lifted from the Virginia Declaration of Rights, which was a 1776 document, and it was proposed by the Virginia delegates to the convention. And the Virginia document itself lifted the language from the English Bill of Rights, a 1669 document. So I think part of the reason there might not have been such a huge debate about it was because the language was familiar to the founders from these other documents. It wasn't just Virginia's Declaration of Rights. There were other state constitutions that had similar language. So I think that's possibly a reason why there wasn't a lot of debate about it. I mean, it would be nice if we had a better sense. Again, if I'm an originalist or someone who cares about original meaning, it would be nice if we had a better sense about what those terms meant. I will say, for anyone who really wants to dig in deeper, because it's fascinating, John Stiniford, who's a professor at the University of Florida, has done some amazing work trying to excavate a little bit more the meaning of these terms. And he's someone, I think, who thinks original meaning and originalism has some legs. And I think he's done some great historical work trying to figure out a little bit more. So I viewed my contribution here as sort of adding to some of that work, because no one had looked at the law of slavery up until the point that I wrote this article. At least no one had looked at the law of slavery for this purpose, right? So that's part of the reason we don't know so much about what it meant to the framers.
And then, yeah, that's interesting. And then the how did slavery itself kind of define cruelty, and how did it come to be, kind of fold into the Eighth Amendment?
So they, at least again on its formally, I think there's lots of echoes in the way the courts that talked about cruel and unusual punishment in the context of slavery. There's lots of echoes of current ways of talking about it. So they, first of all, equated cruel and unusual punishment with excessive punishment. A lot of the courts would use language about, well, it is okay to use quote unquote moderate correction of an enslaved person, but it can't go into the line of excessiveness. And what does it mean for punishment to be excessive? It means when it is punishment that seems to be inflamed by passion instead of by an actual need to inflict that correction. Now, again, I just want to be really clear. We're talking about an inhumane system, right? So I don't think any of us thinks there was ever any need to engage in any of this, but at least in the language of the case law, this is how the cases talked about it. So I just want to bracket that and say, okay, that's one way that cases talked about cruel and unusual punishment. And I want to connect that to the way courts talk about the Eighth Amendment today, because this to me is one place where I think it really causes us, I hope it would cause us to rethink where we are with our Eighth Amendment jurisprudence today. If you look today at the Eighth Amendment jurisprudence about excessive use of force, you would see almost identical language, at least in terms of its spirit. What is excessive force under the Eighth Amendment? It is force that goes beyond that which is necessary to maintain order, but instead force that reflects malice or sadism, right? It is force that is inflamed by passion, not force that is motivated by legitimate penological interests. And so for me, when I was reading those cases about excessive punishment and particularly excessive use of force in the slavery context, the lights went off for me because I had read so many of the cases about the use of force in prison. And it doesn't mean they're the same, right? It just means that to some degree, they're sending the same signal, which is some force, some punishment, some pain is okay. But when you're motivated by something beyond the legitimate penological interest, or in the context of slavery, the legitimate need to correct an enslaved person, so to speak, then that's when it becomes a problem. So that's one thing that cruel and unusual punishment means. The second thing that the cases established in the context of the law of slavery is that it goes beyond mode of punishment. That is, in the context of slavery, it was not unusual for an enslaved person to be whipped. But just because it wasn't unusual for an enslaved person to be whipped didn't mean that you could whip an enslaved person as much as you wanted. That is, again, as a formal matter, the law of slavery says there's a limit, interpreting the words cruel and unusual punishment. So this helps shed some light on whether or not you can ever have a punishment in the Eighth Amendment context that we all accept as part of the criminal legal system, but that in some circumstances might go too far. So that's another thing I think that the 18th and 19th century case law says about the law of slavery. And I think those are two of the most important insights I think that we can take from it.
Yeah, and I would like to tie it kind of what you were just talking to the idea of these laws were not meant to protect slaves.
Right.
They were meant to punish when it went overboard. And if you could talk a little bit about that in the context of today's prisons. I mean, I know you don't so much in the article, but I suspect that there's a through line there.
Yeah. So they weren't That's right. They were not meant to protect enslaved people. I think they were principally meant to protect the property interests of slaveholders. And so I think that probably, I think you could argue that the law of prisons is slightly different in this respect. I do think that a trend has emerged in which we could say that the law of the Eighth Amendment is informed to some degree by dignity, principles of dignity, and the dignity of every human being, even if they are incarcerated. So I think I think that's you can see that in a few contexts. So, for instance, if I'm in prison and I need medical care, the state has to give it to me. If we're living on the street, right, we don't live in a world on the street in which we have a constitutional right to medical care from the state. But if I'm in prison, I do actually have a constitutional right to medical care. Now, it's not the best medical care. It's not. I don't get to choose my doctor. I don't even get to, And if a doctor in prison chooses one treatment over another, and it turns out the doctor made a mistake, I don't get anything. I don't have a cause of action for that. That's just maybe it's negligence, but it's not a violation of the Eighth Amendment. Similarly, as I walk around on the street, I don't have a constitutional right to be protected from other people. I don't have a right to have the police respond to my request for assistance if I make one. Whereas if I'm in prison, the state does have an obligation to protect me from harm inflicted by other people. Again, it's a minimal level, but it's something. So I think in that respect, there are differences, right? And I have the right as an incarcerated person to ask for that protection, whereas enslaved people didn't have a right to do anything. But at the same time, I already made the connection about excessive force. There's another connection I want to make, which is, if you read these cases from the 18th and 19th century, when they talk about cruel and unusual punishment, sometimes they coalesce around this idea about decency and the proprieties of social life. Now, I mean, they're talking about decency and the proprieties of social life in the context of, as we've already said, an inhumane and dehumanizing system. But again, the idea of decency and evolving standards of decency is another animating feature of the Eighth Amendment, of Eighth Amendment jurisprudence. And so there's, in some ways, broad brush, we're talking about marginalized groups and subordinated groups, right? And the question is, what law governs subordination? So I think there are lots of differences between them, but at the same time, some of these principles that run throughout are important. And the other thing is, I would say, as much as I've said that the law of slavery is formal and, we shouldn't be pretending that it was enforced in any real way. We could also talk about the law of prisons as formal in some ways too. That is, one of my mentors who's done litigation on behalf of incarcerated people for much longer than I have, likes to say, of all the places where you think the law would have force, it would be prisons. After all, like, we're putting people there because they broke the law. We're using the force of law, the power of the state, to take away their liberty. You would think if anywhere the law has meaning, it would be there. And in reality, that is often not true. That is, we can talk about all the constitutional rights that incarcerated people have. Enforcing them is very difficult. There's all sorts of barriers to enforcement. And in practice, there's a lot that goes unenforced. So there's also some similarities in that respect.
Yeah, and I mean, one of the things that I think I would like to just bring up at this point is the fact that the rise of the penitentiary system, when Reconstruction ended, was very much a like a continuation of slavery.
Yeah.
And that, to one reading, that continues today.
Well, I think that's correct. I mean, there are still some institutions that if you walk into them, it's unmistakable, the connection between um, enslavement and the rise of the penitentiary. And there's other people have written about this far more effectively than I have, but especially that critical moment post-Reconstruction, pre-World War II, and the efforts by Southern states to maintain that source of free labor that they had benefited from during slavery, and to keep benefiting from that by expanding and incarcerating Black people has been written about by many people, and is something I think we still live with to this day.
Yeah, and that kind of brings us back to the kind of your concluding point about how, if you look at the language, it hasn't changed much. There isn't much evolution in cruel and unusual definitions and how it's applied. So maybe you'd like to.
Yeah, so I think that this is the challenge of constitutional interpretation. The words themselves haven't changed, and absent a constitutional amendment, they're not going to change. They've been interpreted, I think slightly differently over the years, and it all begins in 1976, and since 1976, really, that was the first case where the Supreme Court said essentially that the Eighth Amendment regulates not just the sentence that you receive, but also the experience of incarceration. And that, I think, led to a number of cases that regulated the fact of incarceration and the lived experience of incarcerated people, and not just how long they're in or whether they're subjected to the death penalty. So that's been I think a big change. But the what my goal was to sort of draw some parallels to help these two categories of constitutional theorists think about where we are with the law of prisons. So, and some of these I've talked about, but it's worth digging into them a little bit. So, for instance, the evolving standards of decency, right? Evolving standards of decency is really a catchword for a living originalist. And I think of all of the constitutional rights that are interpreted, the Eighth Amendment is the one in which the Supreme Court has probably most explicitly adopted a living originalist approach. I'm sorry, a living constitutionalist approach. And it's done so for quite some time. I mean, it started thinking about this at least as early as 1910 in a case called Weems versus United States. Was the court adopted a living constitutionalist approach to interpreting the Eighth Amendment. So part of my challenge for someone who buys into that approach is to say, okay, well, we say we're living constitutionalists. You say you've got the standard evolving standards of decency. At least in some areas, the understanding of cruel and unusual punishment does not seem like it's changed all that much from the 18th and 19th century to today. And again, the best example for me is the language around infliction of pain and use of force. And so if I'm a living constitutionalist, if I'm someone who thinks evolving standards of decency is an appropriate measure of the meaning of the Eighth Amendment, then I think I have to ask myself, how much have we really evolved? Is what we're applying really reflective of evolving standards of decency? If we have cases in which courts say that it is not a violation of the Eighth Amendment to pepper spray an incarcerated person in the face for no reason, and there are some courts that would say that it's not a violation of the Eighth Amendment, then how far have we evolved? So that's one piece of it. And then the other piece of it is, as I sort of led us, as I led off with, this debate about proportionality and this debate about whether or not we can find in this language, cruel and unusual punishment, a proportionality principle. To me, I think the law of slavery is a pretty strong indicator that we can. At least, again, if we care about how that language was interpreted in a different context, but to the same effect, which is to say, there's the cruel and unusual punishment can embrace a principle of proportionality, even when the kind of punishment you're using is something that is a mode of punishment is well accepted. So again, if that's a challenge to the originalists, right? That's a challenge to someone who cares about original meaning, is to say, if you do care about that, then you should try to account for why this language, identical language, also about subordinate relationships of subordination, also really in a way about the power of the state, because one of the things I point out in my paper is that to some degree, the relationship between slave owner and enslaved person was the relationship of state citizen. That is, the state essentially gave all of its power to the slaveholder. If that's the case, then we really need to account for it if you're someone who believes in original meaning. And I think there's a strong argument that the proportionality principle should be embraced, even if I'm an originalist, within the meaning of cruel and unusual punishment.
That's excellent. And just to kind of clarify that last point about the state and slave owner, that was done through, they were basically judge, jury,
executioner, right? And so there was so little regulation of that relationship. Again, as I said, sort of at some point as we were talking, there, again, on the books, there were some jurisdictions which said, well, if a slave owner kills or maims, and it's excessive, whatever that means in that context, how could it not be? Then there was, at least theoretically, the possibility of criminal liability. There were so few prosecutions, right? And I don't know if any of them was ever successful, but there were very few criminal prosecutions. And we don't need a very vast imagination to understand that probably, if that really was the standard, there should have been a lot more prosecutions, right? So that just, I think, bespeaks of the gap between whatever the law was saying formally and the way it was working in practice.
Well, this is great. Thank you. We've had a lot of problems here in Cuyahoga County with our corrections facilities. And at one point we were under federal oversight. So it's been a topic in the general discussion of our community.
Yeah, I think it's a topic nationwide, and I think it's good, right? I think there's a lot of discussion around overcriminalization and the costs of incarceration, the human cost of incarceration on families and on incarcerated people. So I'm hopeful that we'll continue to have that conversation.